I'm Helene, 32, a biochemist with multiple advanced degrees who developed a groundbreaking medical compound that revolutionized treatment for millions. At our company gala, my CEO publicly called me decorative while taking credit for my work. He never imagined my signature on the licensing agreement would be his downfall. When our 9-figure lawsuit reached the courtroom, everything changed with one simple question. Before I dive into how I took down a multi-million-dollar company with a single signature, drop a comment letting me know where you're watching from, and hit that subscribe button if you've ever been underestimated at work. Science has always been in my blood. Growing up with 2 researcher parents who transformed our kitchen into an impromptu laboratory on weekends, I was destined to fall in love with the mysteries of biochemistry. My father, a renowned chemist, and my mother, a brilliant biologist, created an environment where questions weren't just encouraged, they were expected. By age 10, I had my own microscope and spent hours examining anything I could find. My parents never treated my curiosity as cute or a phase. They saw it as the foundation of a scientific mind. My academic journey took me through some of America's most prestigious universities. I earned my undergraduate degree in biochemistry from Stanford University, graduating with highest honors before continuing to Harvard for my doctorate. Those years weren't easy. The gender imbalance in STEM fields was painfully obvious, with lecture halls filled predominantly with men. I often found myself the only woman in study groups or research teams. My doctoral research on novel pharmaceutical compounds caught the attention of several major companies, but the offers always came with subtle hints that I would be more of a supporting player than a leader. Our team could use a fresh perspective like yours. One recruiter told me his emphasis on fresh, making it clear they valued my difference more than my expertise. Another told me I would add diversity to their promotional materials, as if my primary value was photographic. It was during a pharmaceutical conference in Boston that I first met James Montgomery. Tall, conventionally handsome, and dressed in an impeccably tailored suit, he moved through the room with the confidence of someone who had never been questioned. Unlike the other businessmen who glazed over when I discussed molecular structures, James listened attentively, asking surprisingly insightful questions, despite his limited scientific background. "I know business, not biochemistry," he admitted freely over coffee after my presentation. "But I recognize revolutionary ideas when I hear them, and I believe you're onto something that could change lives." His straightforward acknowledgement of our complementary skills was refreshing. "I have the connections and capital to start a company, but I need someone with the scientific brilliance to create products that matter." That conversation led to the formation of Montgomery Pharmaceuticals 6 months later. On paper, James was the CEO and I was the chief scientific officer, but in those early days our partnership felt equal. We leased a small lab space in Cambridge, recruited a team of 4 researchers, and began developing products based on my earlier research. Our first success came with a modified antibiotic that reduced side effects compared to market alternatives. It wasn't revolutionary, but it established our reputation and brought in enough revenue to expand our operations. I spent 16-hour days in the lab, refining formulas and running tests, while James secured funding and navigated regulatory requirements. As the company grew, so did our team. I hired Patricia Johnson, a methodical and brilliant research assistant, whose attention to detail saved us from countless errors. Richard Taylor joined as our company lawyer, a quiet man with wire-rimmed glasses who seemed to anticipate legal issues before they arose. And David Winters, one of our early investors, joined the board with a genuine appreciation for the science behind our products. The early years of Montgomery Pharmaceuticals were exhilarating. I led a growing research department that respected my leadership and expertise. James and I made decisions together, our different perspectives strengthening the company. We celebrated each milestone together: FDA approvals, new hires, our first $1 million in revenue. "We make a good team," James said after we signed our first major distribution deal. "Your brains, my business sense. Together we're unstoppable." I believed him then. I thought we were building something meaningful together, something that valued both the science and the business equally. I didn't see how the balance of power was already beginning to shift. or how my role in our success story was slowly being rewritten. The night I discovered the compound that would change everything began like many others, with me alone in the lab well past midnight reviewing test results that didn't make sense. Our team had been working on a treatment for a degenerative nerve condition that affected millions worldwide, but all our approaches had failed. I was staring at data from our latest trial, frustrated by another dead end, when I noticed something unexpected in one of the control samples. A molecular reaction that shouldn't have happened did. I double-checked my notes, ran the analysis again, and felt my heart race as the implications became clear. The accidental combination of two compounds we'd previously tested separately had created something entirely new, something with the potential to repair nerve damage we previously thought irreversible. I called Patricia immediately, not caring that it was 2 a.m. "You need to see this," I told her. "I think we just stumbled onto something incredible." The next 6 months were a blur of testing, refinement, and cautious excitement. I led our team through countless iterations of the formula, testing different concentrations and delivery methods. The compound, which we eventually named Neurogen, consistently showed remarkable results in lab testing. When we began animal trials, the results exceeded even my most optimistic projections. The nerve regeneration rates are unlike anything previously documented. I explained to our board, pointing to the comparison charts. Patients who've lost mobility could potentially regain it. This could help millions suffering from conditions we currently consider untreatable. James, sitting at the head of the table, was uncharacteristically quiet during my presentation, but his eyes gleamed with an intensity I recognized. He was calculating potential profits. When I finished, he stood up and placed his hand on my shoulder. "This is why I brought Helene on board," he told the board members. "I knew she had this kind of breakthrough in her." The phrasing struck me as odd. He brought me on board as if I were a hire rather than a co-founder, but I was too excited about the compound to dwell on it. As clinical trials began, the press took interest in our potentially revolutionary treatment. James, always comfortable in the spotlight, handled most of the interviews. At first, he mentioned me prominently, our brilliant CSO, Dr. Helene Parker. But over time, the narrative shifted subtly. The breakthrough became Montgomery Pharmaceuticals' discovery, or sometimes just my company's innovation. In a feature for Pharmaceutical Executive magazine, James was photographed in our lab, wearing a white coat he never normally wore, looking thoughtfully at vials of our compound. The accompanying article mentioned me in a single sentence, describing me as heading the research team. When I pointed this out to James, he brushed off my concern. "It's just PR, Helene. The business world relates better to a single visionary than a team. It's better for our company image." I began noticing other subtle changes. Executive meetings that once included me from the start now began with business discussions to which I was invited when the scientific aspects need addressing. My input on strategic decisions was requested less frequently. James began hiring executives from his previous business connections, mostly men who addressed their questions to him even during presentations about my research. Through it all, I remained focused on perfecting Neurogen. The clinical trials showed unprecedented success rates, with 87% of participants showing significant improvement. The FDA fast-tracked our application, recognizing the compound's potential to help patients with limited treatment options. While James was increasingly occupied with investor meetings and press appearances, I worked with our legal team on the critical patent and licensing documentation. As the primary inventor, my signature was required on the original licensing agreement, the document that outlined who controlled the rights to manufacture and distribute Neurogen. The day the final paperwork arrived, our office was chaotic with preparations for an investor presentation. Richard, our lawyer, brought the licensing agreement to my lab rather than calling me to the conference room where James was holding court. "You should read this carefully before signing," Richard said quietly, his expression unreadable behind his glasses. "Particularly Section 7 regarding inventors' rights." I skimmed the dense legal text, noting with satisfaction that my name was listed as primary inventor, with full details of my contribution documented. Section 7, which Richard had pointed out, confirmed that as the inventor, I retained certain licensing authority regardless of company ownership structures. Is this standard? I asked. It protects your intellectual contribution, Richard replied carefully. James is in a hurry to file this before tomorrow's meeting. He's asked me to get your signature immediately. Something in Richard's tone made me read the document more thoroughly before signing my name with a flourish. As he collected the papers, Richard added, "You might want to keep a copy for your personal records, just as standard practice." I didn't realize then how crucial that suggestion would prove to be, nor did I understand that my signature on that licensing agreement would eventually become the most powerful card in my hand. Montgomery Pharmaceuticals spared no expense for the gala celebrating Neurogen's FDA approval. The grand ballroom of the Four Seasons Hotel glittered with crystal chandeliers reflecting off champagne flutes and designer evening wear. After 5 years of building the company from nothing, we had arrived at the pharmaceutical industry's most coveted milestone, a revolutionary drug approved for market. I chose a deep blue gown for the occasion, classic and professional, yet elegant enough for the celebration. Patricia, now my research director, joined me at a table near the front, along with several key members of our research team. The atmosphere buzzed with victory as investors, board members, and executives mingled with the scientists who had made Neurogen possible. James commanded the room in a custom tuxedo, moving from group to group with practiced ease. When he approached our table, he clinked his glass against mine. "The woman of the hour," he said warmly. "Tonight is your triumph too." The "two" caught my attention, a small word that somehow placed my contribution as secondary. But I smiled and accepted the compliment, believing the evening would acknowledge the truth of our joint accomplishment. When dinner concluded, the lights dimmed and James took the podium. A video began playing on the large screens around the room, beautifully produced footage of our lab's clinical trial patients sharing emotional testimonials and stock prices climbing. My team and I appeared briefly in background shots, but the narrative centered entirely around James's vision and leadership. 5 years ago, I had a vision, James began. When the video ended, I saw an opportunity to create something that would change lives. I invested my resources, built this company from the ground up, assembled a team of talented researchers, and today we stand at the threshold of a new era in medicine. I maintained my professional smile, though my stomach tightened as James continued his speech, without any mention of my role in founding the company or discovering the compound. He thanked investors by name, acknowledged board members, even mentioned our marketing team, but not the scientists who had created Neurogen. "Of course we have an excellent research department," he finally said, gesturing vaguely toward our table. "Helene and her team executed the technical aspects beautifully." Executed the technical aspects, as if I had merely implemented his scientific ideas rather than originated the entire breakthrough. What happened next burned itself into my memory frame by painful frame. "Helene has been with us since the early days," James continued with a smile that didn't reach his eyes. "Not only is she smart, but she's decorative too, a nice addition to our team photos." A wave of shocked silence washed over the room before scattered chuckles broke the tension. James continued speaking, but I could no longer hear him over the rushing in my ears. Decorative. After all my years of education, all the 60-hour weeks in the lab, all the scientific innovation I had brought to his company, I was reduced to ornamentation. I felt Patricia's hand grip mine under the table. Across the room, I caught David Winter's uncomfortable expression, his eyes darting between James and me. Most disturbing were the reactions around the room. Some genuine discomfort, yes, but also knowing smiles, as if James had finally said aloud what many had thought all along. Through sheer force of will, I maintained my composure. I didn't storm out. I didn't cry. I didn't cause a scene. When James concluded his speech to applause, I joined in mechanically, feeling as though I were watching myself from a distance. The rest of the evening passed in a blur of forced smiles and autopilot conversations. He had no right to say that. Patricia fumed as we waited for the valet after the event. "Everyone knows Neurogen would not exist without you." "Apparently not everyone," I replied, my voice steadier than I felt. Back home, I removed my elegant gown and stared at my reflection in the bathroom mirror. Behind me on the vanity sat framed articles about our breakthrough, my PhD diplomas awards for scientific achievement. Decorative. The word echoed in my mind, stripping away my credentials, my contributions, my worth to the company I had helped build. The next morning, Patricia arrived at my office with coffee and a determined expression. "People are talking about what happened," she said without preamble. "Most of the research team is outraged on your behalf. And the executives I asked already knowing the answer. Business as usual," she admitted. "But there's something else you should see." She placed a draft of our new company brochure on my desk. The glossy cover featured James in the foreground with our executive team behind him. I searched the image before realizing I wasn't in it. "They did a new photo shoot last week," Patricia explained. "You weren't invited." I flipped through the pages, a cold certainty settling in my stomach. The story of Neurogen's development had been rewritten. James was now described as having directed the research initiative that led to the discovery, while I was mentioned only as part of a dedicated scientific team. Over the following days, I discovered this wasn't an isolated incident. Press releases referred to Neurogen as James Montgomery's breakthrough treatment. Internal communications increasingly positioned him as the visionary behind the science as well as the business. My contributions were being systematically minimized, my role in the company's history rewritten page by page. "I should resign," I told Patricia one evening as we worked late in the lab. "That's exactly what he wants," she countered fiercely. "For you to leave so he can completely take over your work." Her words jolted something in my memory. The licensing agreement Richard had so carefully ensured, I signed and kept. I pulled the document from my files, reading it with new understanding. My signature on that paper wasn't just a formality. It granted me specific rights that even James, with all his corporate maneuvering, couldn't erase. For the first time since the gala, I felt something other than humiliation. I felt the stirring of power, the power of knowledge, of foresight, of documentation. James had called me decorative, but he had forgotten something critical. Decorations don't sign licensing agreements. The Monday after the gala, my keycard denied me access to the advanced testing lab, where we were developing next-generation applications for Neurogen. I stood in the hallway swiping repeatedly, while the small light flashed red, a denial as clear as James's message at the gala. "System glitch," the IT department claimed when I called. "We'll have it fixed by tomorrow." But the next day, I received an email announcing security protocol updates requiring adjusted access levels based on current project involvement. My access was never restored. At that week's executive meeting, I found a stranger sitting in my usual seat, a silver-haired man with an expensive watch and a confident smile. "Helene, meet Wallace Thornton, James," introduced casually. "He's joining us as Executive Vice President of Research and Development. Wallace comes to us from Merck with extensive experience commercializing breakthrough compounds." The message was unmistakable. Wallace, who had no involvement in Neurogen's development, was now positioned above me in the company hierarchy. As the meeting progressed, Wallace spoke authoritatively about next steps for my compound, referring to data from meetings I hadn't been invited to attend. "We've been conducting some preliminary market analysis on potential applications," Wallace explained, sliding glossy reports across the table, reports I was seeing for the first time. "I wasn't aware of these meetings," I said, keeping my voice level. "Just expediting the process," James replied smoothly. "You're so busy with the technical side, we didn't want to burden you with marketing discussions." The pattern continued. I found myself excluded from crucial emails. Meetings about Neurogen were scheduled during my known lab hours. My budget approval authority was restricted to streamline operations. My research team was gradually assigned to projects reporting to Wallace rather than me. When I discovered a patent application filed for a Neurogen delivery system that omitted my name entirely, I finally confronted James directly in his office. "You're systematically removing me from my own work," I said, placing the patent application on his desk. "My name should be on this." James leaned back in his leather chair, studying me with the detached interest of someone observing an unexpected reaction in a controlled experiment. Helene, you're overreacting, he said with a patronizing smile. The company owns all intellectual property developed here. That's standard. Your contribution to the original compound is documented, but this delivery system was developed by the broader team. A team following my research protocols, using my methodology, I countered. Your methodology, James raised an eyebrow. Montgomery Pharmaceuticals' methodology, you mean? Everything developed here belongs to the company. Besides, Wallace has brought valuable insights that have accelerated the commercialization process. You can't erase me from Neurogen's history, I insisted. History, he laughed. This isn't about history, it's about business. And frankly, Helene, your skills are in the lab, not the boardroom. We value your technical contributions, but the bigger picture requires different expertise. I left his office shaking with rage and humiliation, but also with growing clarity. This wasn't a misunderstanding or personality conflict. It was a calculated campaign to diminish my role and claim my work. That evening, I began meticulously documenting everything. I gathered lab notebooks, research plans, email communications, early drafts of papers, anything that established the timeline of Neurogen's development and my central role in it. Patricia helped retrieving records from secure servers before they could be altered or deleted. James is meeting with Avalon Biotech executives next week, David Winters called to tell me privately. They're discussing acquisition terms based primarily on Neurogen's value. Acquisition, this is the first I'm hearing of this, I replied, though nothing surprised me anymore. The board hasn't been formally notified yet, David said, his voice low. But the preliminary valuation is 9 figures. James stands to make hundreds of millions personally. From my discovery, I said quietly. From your discovery, David confirmed. And Helene? There's more. The restructuring plan he's presenting next month eliminates your position entirely. You'd be offered a role as scientific consultant with no leadership authority. The final piece fell into place 2 days later when I overheard Wallace in the hallway. Once the Avalon deal closes, we won't need to worry about her anymore, he was saying to someone. The transition team has no place for her in the new organization chart. That night, I contacted Elizabeth Michaels, a lawyer specializing in intellectual property and pharmaceutical patents, who had no connection to Montgomery Pharmaceuticals. I brought copies of everything I had gathered, including my carefully preserved original of the licensing agreement. They're planning to sell the company based on my discovery, then push me out completely, I explained. I need to know what options I have. Elizabeth reviewed the documentation carefully, her expression growing increasingly interested as she read through the licensing agreement. Dr. Parker, she said, looking up with the first smile I'd seen in weeks. Did you understand what you were signing when you executed this licensing agreement? I knew it acknowledged me as the inventor, I admitted. But I'm not sure I grasped all the legal implications. This agreement does more than acknowledge you, she explained. Section 7 grants you as the primary inventor continuing licensing authority. In simple terms, while Montgomery Pharmaceuticals can develop and profit from Neurogen, they cannot transfer those rights to another entity without your explicit consent. So if they try to sell the company, I began the implications dawning on me. Any acquisition focused on Neurogen would require your signature to be valid, she confirmed. And there's no indication in any of these documents that you've waived that right. For the first time in months, I felt something other than despair. I felt powerful. James had been so focused on erasing me from the company narrative that he had overlooked the legal documentation that gave me actual control. What's our next step? I asked. We gather more evidence, strengthen our position, and wait for the perfect moment, Elizabeth advised. Let them continue believing they can proceed without you. When they announce the acquisition publicly, that's when we act. Elizabeth's downtown office became my sanctuary over the next few weeks. Far from Montgomery Pharmaceuticals' gleaming headquarters, we meticulously built our case in a conference room lined with legal texts and case files. The licensing agreement is our foundation, Elizabeth explained during our first strategy session. But we need to establish a clear pattern of behavior showing deliberate marginalization and intention to proceed with the acquisition without your legally required consent. Together, we created a detailed timeline documenting my role in developing Neurogen and the subsequent efforts to minimize my contributions. My lab notebooks provided irrefutable evidence of the compound's discovery process. Emails and meeting minutes tracked how I was gradually excluded from decisions about my own invention. The company brochures and press releases demonstrated the progressive erasure of my name from Neurogen's story. Richard, the company lawyer who had ensured I signed and kept the licensing agreement, took an enormous professional risk by secretly providing internal documents about the planned acquisition. "I believe in the law more than I believe in James Montgomery," he told me, during a clandestine meeting at a coffee shop 3 blocks from the office. "What they're doing isn't just unfair, it's illegal." The documents Richard provided revealed the depth of James's deception. Board presentations outlined an acquisition strategy centered entirely around Neurogen, with financial projections showing how the compound would generate billions over its patent lifetime. A draft press release announcing the acquisition made no mention of me whatsoever, crediting James as the innovative force behind Neurogen. Most damning was an email from James to Wallace discussing how to handle potential objections from me. "By the time she realizes what's happening, the deal will be done. Her signature isn't necessary. Legal has confirmed we have full rights to the IP." "He's wrong about that," Elizabeth noted with satisfaction when I showed her the email. "This proves they're deliberately proceeding without your consent, knowing your invention is the primary asset." As we built our case, Montgomery Pharmaceuticals announced record quarterly profits driven by Neurogen's initial sales. James appeared on CNBC confidently predicting exponential growth and hinting at strategic partnerships in the company's future. His arrogance grew with each public appearance, his narrative increasingly centered on his own brilliance and foresight. "The bigger his claims become, the stronger our case gets," Elizabeth observed. "He's creating a public record of statements that contradict the documented facts." We timed our legal strategy, carefully monitoring the business press for signs that the Avalon acquisition was moving forward. When the Wall Street Journal published a small item about Avalon Biotech in talks with a smaller firm regarding a major acquisition, we knew our window was opening. Elizabeth filed our lawsuit the day before Montgomery Pharmaceuticals was scheduled to announce the acquisition publicly. The legal complaint was comprehensive. Over 200 pages, documenting my role as inventor, the systematic effort to remove me from decision-making, and the planned illegal transfer of licensing rights without my consent. The media initially portrayed the lawsuit as I had expected, a disgruntled female scientist jealous of her male boss's success. Business publications quoted sources close to Montgomery describing me as difficult and unable to adapt to a growing company's needs. Online comments questioned my motives, suggesting I was opportunistically seeking a payout from the company's success. "Don't read the comments," Elizabeth advised firmly. "Remember that public opinion isn't the arbiter here, the law is, and the law is on our side." The emotional toll was significant. Former colleagues avoided me. Industry peers questioned my judgment in pursuing legal action. My professional reputation, built carefully over decades, was suddenly reframed as that of a troublemaker who couldn't work within corporate structures. "Is it worth it?" I asked Elizabeth during a moment of doubt. "Even if we win, who will hire me after this?" "First, we are going to win," she replied with certainty. "Second, you won't need to be hired. When this is over, you'll be in a position to build something new, something better than what James tried to steal from you." The lawsuit halted the acquisition talks immediately. Avalon Biotech's lawyers, suddenly aware of the licensing complications, put all negotiations on hold, pending resolution of the legal issues. Montgomery Pharmaceuticals stock dropped 15% the day our lawsuit hit the news. James's initial response was dismissive. "A nuisance suit without merit," his spokesman called it. An unfortunate attempt to capitalize on the company's success by someone whose contributions, while appreciated, have been vastly overstated. But behind the scenes, a different story unfolded. Through Richard, we learned that James had exploded when served with the lawsuit, smashing a glass against his office wall and shouting that I would never work in this industry again. More importantly, Avalon's due diligence team was now asking pointed questions about the licensing agreement and my role as inventor, questions James struggled to answer. The case was assigned to Judge Sandra Wilson, known for her meticulous approach to intellectual property disputes. When James's legal team attempted to have the case dismissed, Judge Wilson denied their motion, writing in her decision that the plaintiff has presented sufficient evidence to warrant full consideration of her claims regarding licensing authority. As the trial date approached, Montgomery Pharmaceuticals launched a more aggressive strategy. Anonymous sources suggested to reporters that I was mentally unstable, that I had stolen research from colleagues, that I was motivated by a personal vendetta against James after he rejected romantic advances, all desperate fabrications meant to discredit me. "They're getting scared," Elizabeth observed. "These tactics show they know their legal position is weak." The day before the trial began, James's lawyers approached with a settlement offer. $5 million in exchange for my signature on the licensing transfer and a non-disclosure agreement. "Should we consider it?" I asked Elizabeth. She looked at me steadily. "Neurogen will generate billions over its patent lifetime. They're offering you less than 1% of its value, plus you would have to agree never to tell your story." She paused. "But more importantly, would it feel like justice to you?" I thought about the years of work, the late nights in the lab, the moment of discovery. I thought about being called decorative in front of my peers. I thought about the systematic erasure of my contributions. "No," I said finally. "It wouldn't feel like justice at all." "Then we go to court tomorrow," Elizabeth replied with a smile, "and we bring the original licensing agreement with us." The federal courthouse stood imposing against the morning sky, its stone columns and broad steps projecting a sense of gravitas appropriate for the battle ahead. News vans lined the street, their satellite dishes raised like modern sentinels. Reporters called out questions as Elizabeth and I climbed the steps, my hand clutching the leather portfolio containing the original licensing agreement. "Just focus on the doors," Elizabeth murmured. "We have truth on our side today." Inside the wood-paneled courtroom, James and his legal team already occupied the defendant's table. His navy suit perfectly tailored his posture, relaxed. James exuded the confidence of a man who had never lost a significant battle. Flanking him were 3 attorneys from Geller and Marks, one of the nation's most expensive corporate law firms, their leather briefcases arranged precisely before them. Our side looked modest by comparison, just Elizabeth, her associate Timothy, and me, but in my portfolio lay the document that would change everything. The gallery behind us filled quickly with journalists, industry observers, and a few familiar faces from Montgomery Pharmaceuticals. Patricia sat directly behind me, her presence a silent affirmation of support. Richard was nowhere to be seen. His confidential assistants would remain hidden to protect his position. "All rise," the bailiff announced as Judge Sandra Wilson entered. In her late 50s, with silver-streaked hair and piercing eyes, she carried herself with quiet authority, her reputation for fairness and attention to detail preceding her. "Be seated," she instructed, arranging her papers methodically. "Parker versus Montgomery Pharmaceuticals, case number 2023CV4276. We'll begin with opening statements." Elizabeth approached the podium first, her voice clear and measured. "Your Honor, this case ultimately centers on a simple question: who has the legal right to transfer the licensing for a revolutionary medical compound called Neurogen? The evidence will show that Dr. Helene Parker is not only the primary inventor of this compound, but also maintains specific licensing authority under the original agreement signed by all parties. Montgomery Pharmaceuticals has systematically marginalized Dr. Parker's role, restricted her participation in decisions about her own invention, and now attempts to transfer licensing rights to another company without her legally required consent. James's lead attorney, William Geller, silver-haired and imposing in an expensive suit, presented a very different narrative. Montgomery Pharmaceuticals has always operated within standard industry practices regarding intellectual property developed by its employees. While Dr. Parker made contributions to the research team, The company provided the facility's funding, direction, and business expertise that transformed a laboratory finding into a viable medication. This lawsuit represents an unfortunate attempt to extract additional compensation beyond the generous salary and benefits Dr. Parker has received throughout her employment. Judge Wilson listened impassively to both sides before stating, "I've reviewed the filings in this case with interest. Let's proceed with the plaintiff's evidence." Over the next several hours, Elizabeth methodically established my role in discovering Neurogen through laboratory records, early patent filings, and testimony from Patricia about the research process. She then traced the pattern of my gradual exclusion through emails, meeting minutes, and company publications that progressively minimized my involvement. Throughout this testimony, I watched James's expression shift from casual dismissal to growing discomfort as the evidence mounted. His attorneys passed notes to him frequently, his responses becoming more terse as the day progressed. When James took the stand the following morning, he presented himself as the visionary businessman who had made Neurogen possible. "I founded Montgomery Pharmaceuticals with the specific goal of developing breakthrough treatments," he testified smoothly. "I raised the capital, built the facilities, hired the researchers, including Dr. Parker, and created the environment where innovation could flourish." "And who actually discovered the Neurogen compound?" Elizabeth asked during cross-examination. "It was a team effort," James replied. "Dr. Parker was part of that team, working under my company's direction. Yet the original patent application lists Dr. Parker as the primary inventor," Elizabeth noted. "Did you instruct your legal team to list her that way?" "Patent applications have technical requirements about naming inventors," James responded, his smile tightening. "But make no mistake, Montgomery Pharmaceuticals owns all intellectual property developed by its employees." Elizabeth then presented the progressive changes in company materials, showing how my role had been systematically diminished in each iteration. "Can you explain why Dr. Parker's contribution went from discovery of the revolutionary compound in this 2021 press release to technical support in development in this 2023 investor presentation?" she asked. "Corporate communications evolved to reflect the broader company narrative." James replied, a practiced answer that said nothing. "And can you explain why Dr. Parker was excluded from meetings about Neurogen's future development starting in January of this year?" "We were streamlining our management structure," he said. "Not everyone can be included in every meeting." By the third day of trial, the evidence of systematic marginalization was substantial. Judge Wilson had paid particular attention to the internal emails discussing my planned demotion and eventual removal from the company following the acquisition. The pivotal moment came when the discussion turned to the planned sale to Avalon Biotech. James testified confidently about the acquisition negotiations, presenting them as a natural business evolution, benefiting all stakeholders. "Avalon has the global infrastructure to maximize Neurogen's potential," he explained. "This partnership would ensure the treatment reaches more patients worldwide." Judge Wilson, who had asked relatively few questions throughout the proceedings, leaned forward. "Mr. Montgomery," she said, her voice cutting through the courtroom, "a key question in this case concerns licensing authority. Who, in your understanding, holds the licensing authority for the Neurogen compound?" James smiled with practiced confidence. "Montgomery Pharmaceuticals holds all rights to Neurogen, Your Honor. As CEO and founder, I have full authority to enter into licensing agreements on behalf of the company." His attorney nodded approvingly, but Elizabeth caught my eye with a slight smile. "And what do you base that understanding on?" Judge Wilson continued. "Standard industry practice and our company bylaws," James replied. "All intellectual property developed by employees belongs to the company." Judge Wilson turned toward me. "Dr. Parker, do you have a different view on this matter?" This was the moment we had prepared for. With steady hands, I opened my portfolio and removed the original licensing agreement, passing it to Elizabeth. "Your Honor, we would like to enter into evidence the original licensing agreement for Neurogen signed by all parties," Elizabeth said, approaching the bench with the document. "We direct the court's attention to Section 7, which explicitly states that the primary inventor, Dr. Helene Parker, retains specific licensing authority, including the requirement that her written consent be obtained for any transfer of licensing rights to a third party. The courtroom fell silent as Judge Wilson reviewed the document carefully. James leaned forward, whispering urgently to his attorney, who appeared increasingly concerned as he reviewed their own copy of the agreement. "Mr. Geller, does your client dispute the authenticity of this document?" Judge Wilson asked. After a hurried consultation with James, Geller responded, "No, Your Honor, but we contest the interpretation being presented." "The language seems quite clear," Judge Wilson observed, reading aloud from the agreement. "Primary inventor retains licensing authority regarding transfer of rights to entities not party to this original agreement, such transfer requiring explicit written consent. Dr. Parker is clearly identified as the common primary inventor throughout this document." James's face had lost its confident glow, replaced by a tightness around his mouth that I recognized from board meetings when things weren't going his way. "Your Honor," Geller interjected, "this clause is unusual and not consistent with standard industry practices." "Whether it's unusual or not is irrelevant," Judge Wilson replied. "The question is whether it's a binding legal agreement that was properly executed by all parties." She held up the document indicating both signatures, mine and James's, clearly visible at the bottom. "It appears to me that Montgomery Pharmaceuticals cannot proceed with any transfer of Neurogen licensing to Avalon Biotech or any other entity without Dr. Parker's explicit consent." Judge Wilson looked directly at James. "Mr. Montgomery, were you aware of this requirement when you began acquisition negotiations?" The courtroom held its collective breath as James struggled to maintain his composure. "I was advised that we had full rights to proceed with the acquisition," he finally answered carefully, avoiding a direct response to her question. "That doesn't appear to be the case, based on this agreement," Judge Wilson stated. In that moment, I watched years of careful manipulation collapse under the weight of a single document and my signature upon it. James had called me decorative, but he had forgotten something fundamental: decorations don't sign binding legal agreements. Judge Wilson's ruling came down 3 days later, her decision unequivocal. Based on the preponderance of evidence and the clear language of the licensing agreement, this court finds that Dr. Helene Parker, as primary inventor, retains specific licensing authority for the compound known as Neurogen. Montgomery Pharmaceuticals cannot legally transfer these rights without her explicit written consent. Furthermore, the court finds that Montgomery Pharmaceuticals engaged in a deliberate pattern of marginalizing Dr. Parker's role with the apparent intent to proceed with a transfer of rights contrary to the licensing agreement. The business press, which had initially portrayed me as a disgruntled employee, now ran headlines like "Pharmaceutical CEO's Empire Crumbles Over Overlooked Signature" and "Scientist Reclaims Rights to Billion-Dollar Drug." The impact on Montgomery Pharmaceuticals was immediate and devastating. Avalon Biotech terminated all acquisition discussions, unwilling to proceed with a company whose primary asset came with such significant legal complications. The stock price plummeted 64% in a single day, erasing hundreds of millions in market value. Investors filed their own lawsuits against James and the board for failing to disclose the licensing complications. James made one final attempt to salvage the situation, requesting a private meeting with me at his attorney's office. "We can still fix this, Helene," he said, his charm resurfacing like a weapon deployed in desperation. "Sign the licensing transfer, become a major shareholder in the merged company. You could walk away with $50 million. I studied his face, the face of a man who had called me decorative after years of benefiting from my work, who had systematically attempted to erase my contributions, who had planned to discard me once I was no longer useful. "I'm not interested in walking away," I replied calmly. "I'm interested in building something new." With the court's ruling establishing my licensing authority, I found myself in a position of unexpected power. Venture capitalists who had previously seen me only as a scientist now approached with funding offers for a new company built around Neurogen and future compounds. Former colleagues from Montgomery Pharmaceuticals, including Patricia, and several key researchers expressed interest in joining this new venture. Over the next 6 months, I established Parker Biosciences with a founding principle that scientific innovation and business strategy would receive equal respect. Our corporate structure ensured that inventors maintained a meaningful connection to their discoveries with transparent profit sharing and recognition protocols written into the company bylaws. Richard, who had risked his career to help me, became our chief legal officer. I want to work somewhere where the legal department enforces ethical standards rather than finding loopholes around them, he explained. Montgomery Pharmaceuticals never recovered from the fallout. James resigned under pressure from the board, his reputation in the industry irreparably damaged. The company was eventually acquired by a larger pharmaceutical firm at a fraction of what Avalon would have paid, primarily for its manufacturing facilities rather than its intellectual property. On the day we officially launched Parker Biosciences, Patricia brought a bottle of champagne to my new office, which featured glass walls overlooking our research labs rather than being isolated on an executive floor. To signatures that matter, she toasted, clinking her glass against mine. And to never being just decorative, I added with a smile. The journey from that humiliating gala to establishing my own company had been painful but ultimately transformative. I had learned that documentation matters more than perception, that standing up for yourself may bring temporary criticism, but lasting respect, and that sometimes the most powerful response to being underestimated is simply to know your own worth and have the patience to prove it. Now, a year after Judge Wilson's ruling, Parker Biosciences is thriving. We've expanded Neurogen's applications to treat additional conditions and have 3 promising compounds in our development pipeline. More importantly, we've created a company culture that values both scientific innovation and business acumen, where credit is given, where it's due, and where no one is ever reduced to being decorative. If there's one lesson I hope you take from my story, it's this: document everything, know your worth, and never let someone else's narrative about you become your reality. Sometimes justice comes down to having your name on the right piece of paper at the right moment. Have you ever been underestimated at work or school? How did you handle it? Share your experiences in the comments below. And if my story resonated with you, please hit that subscribe button and give this video a like. Your support helps me continue sharing these real-life lessons that might help someone else facing similar challenges. Thank you for listening, and remember, your signature on your work matters in more ways than one.